she left out the information that Sherrone Moore was the boss of the complainant.
The defendant's due process rights are at jeopardy. And taking it from the standpoint that it's like a CEO and the executive assistant to a CEO, there's a lot of communication there. I really have a problem with that. I think that that was an intentional misdirection to the court. So for those reasons.
Let's manage our expectations here. Today isn't the final verdict, and no one is going to prison yet. This is a motion for an evidentiary hearing. But don't look away, because the judge just granted a rare Franks hearing after finding what he called a glaring omission by the police. The defense argues that detectives secured a stalking warrant for Michigan Coach Sherrone Moore by intentionally hiding one simple fact. The alleged victim was Moore's own executive assistant. Those 12 harassing calls the cops used to get the warrant, the defense says they were just business as usual during the high-stress week of the Citrus Bowl. What's more is
the relationship between the parties in a stalking allegation matters. It's not stalking if the communication has a legitimate purpose. As stated in my reply, and as what Your Honor knows, is that under recently published appellate court case in the state of Michigan, it is clear that the relationship between the parties matters. In this case, Detective Welker presented to the magistrate facts to seek an arrest warrant for Sherrone Moore on stalking charges and on home invasion with intent to stalk. In the facts that she presented to the magistrate, she left out the information that Sherrone Moore was the boss of the complainant. The complainant was the executive assistant to Sherrone Moore, who at the time was the head football coach at the University of Michigan. Why does that matter? It matters because the communications that were presented to the magistrate were 12 alleged phone calls that were unanswered. The 12 alleged phone calls were on a work day. The complainant in this case had not taken a leave of absence. She had not left her job. It was working hours, and she was the executive assistant of Sherrone Moore. Sherrone Moore was never told not to contact her for legitimate purposes. In fact, he was never told not to contact her at all, but that's not what we're here arguing right now. I'm talking about the legitimate purpose. If there are contacts for legitimate purpose, it is not harassment. As I stated a moment ago, the phone calls went unanswered. So there's no evidence as to what the intent of those phone calls were. The complainant confirmed that they were work-related. The one where it says, please answer and call when you get a chance, it's my belief that those text messages were also seen as work-related. Those were not part of.
Well, it's your belief, but did she say that, or?
She said to the detective said, was this work-related? And she said, yes, that's work-related. They showed her the whole screenshot, and she said, are these text messages work-related? And the answer was, yes, those are work-related. And then she was asked, are there any more text messages that you haven't given me? And the answer was no. And that's all in the police report.
Okay.
So the reason, again, to connect the dots is that there's acknowledged communication that was work-related during those days. Which goes towards the phone calls. She doesn't know if they're work-related or not. We don't know if they're work-related or not. It's our position they were. It was a work day. There's no evidence to show otherwise. Because the complainant was able to distinguish between communications that were work-related. She identified the text as work-related. At the time of the swear-to, Detective Welker knew that there was an employee-employment relationship. There's quite a bit of case law where omissions are considered Franks violations. Heidi Sharp stated that Mr. Moore had a long history of domestic violence against Shiver. Okay. Shiver herself never made those statements. She never gave that information. There is no record of any of that. There is no documentation of any of that. There is no criminal history. There's nothing to support that statement made by Heidi Sharp. Through 3 interviews, the complainant never says any of that and also doesn't support it. She was asked by Detective Welker about assaultive behavior, and she said, no, there isn't any. And Detective Welker, by submitting to the magistrate Sharp statements instead of the complainant's statements, was reckless and intentional and false.
It really isn't that it's false. It's that she may have portrayed an inaccurate context to everything that's going on by omitting certain things. I don't know that that makes what she said about what Heidi Sharp said false. It's just you haven't given me everything
Right.
to give context to what she's saying, whether to ignore it or not.
Right. I guess maybe the better language would be reckless disregard, which is also part of the analysis. I think reckless disregard is more accurate. So what's the circumstantial evidence here? The circumstantial evidence here is that it was a work day, it was work hours, the employee-employer relationship was intact. There were text messages that were work-related in those time frames that these calls allegedly occurred. And it was, in terms of the dates involved, that was the week that Michigan had found out who their bowl opponent was. That Sunday night, they received their opponent. It was all hands on deck. So I believe those facts are relevant. If this were August and it was a break from the program, yeah, there could be a question. But the circumstantial facts of the timing of these calls, and remember, or not remember, but I will state that at the time these calls were made, Mr. Moore had not been told not to call her and had no idea that she had even gone and talked to general counsel. He didn't know any of that.
I'm taking it from the standpoint that it's like a CEO and the executive assistant to a CEO. And that is typically a very close relationship. There's a lot of communication that happens. And as I was thinking about this case, the only thing that I could sort of in my head equate it to is myself and my judicial coordinator. And that the communication that flows there is different than I have with any other employee in this court. It just is, by nature of the position. If I'm correct in that, and I may or may not be, I think it's something that the court would have had to have been informed of. She has the other text messages from those 2 days, right? Somewhere she saw those, but doesn't say anything about them. Doesn't say anything about what those are. Yet, the one that occurs after on December 10th, well, one particularly,
Yeah.
She lays out in great detail. That I have a problem with because it seems to me, if I were the magistrate, I'm getting half the story. I'm not getting the full story. I find it a problem when the court isn't given all of the information for the court to make a proper determination of probable cause. I really have a problem with that. Because quite frankly, I think that the defendant's due process rights, as well as the right of the people to be able to proceed with a validly sworn out complaint, are at jeopardy. This case brings up sort of a different issue, but brings up the issue of an omission. What is clear from this court's perspective, at least, is that an omission in certain contexts can be more damaging more problematic, more troublesome than what might be an intentional misrepresentation. The defendant wishes this court to have an evidentiary hearing regarding the issues, but fundamentally it's focused around certain portions of the omissions and sort of the context, particularly as I gather from the defendant's argument and what has been a concern of the court is the context of the relationship. And just by way of context, in looking at the swear to by Officer Walker, what's clear, and also from the court's question, I think the parties realized where the court was going and should have. It's all set out by her attorney, Ms. Sharp. Virtually every statement is a rendition of what Ms. Sharp said to the police. It isn't until a little bit later into that swear to that you get into particular statements that are made by the complainant in this case. When one looks at the Eichler case, one of the things that realize and where the defense was heading is that the context, and I read it as broadly as the defense does, that context to stalking charge, context of that relationship is critical to an assessment of that relationship and whether or not there's this harassing behavior or stalking going on. But really, I think that the falsity really comes in the way that it was sworn at. It at worst is false and an outright lie, excuse my language in that regard, or at best, it is misleading. And particularly when it talks about the 10 to 12 phone calls and text messages, there's not one mention of the fact that those to which they could determine were work related. There's not a mention of it. That is a huge, in this court's perspective, that's a huge omission. Because immediately afterwards, again, there's like a statement from the complainant about these 12 calls, making them seem as though they are somehow related to some type of harassing behavior because there's nothing on the other side to say what it may be. And then the immediate statement afterwards is a text message that came after the incidents or later on the 10th, after the issue regarding the complainant's home. Frankly, I think that was intentional. I think it was intentional to place a context without saying it. Give the court a context. If you look at the very beginning, that he's this monster, he's this person that's been doing all of these things, been harassing her for months. You lead that down into all of a sudden this day comes along or the 8th of December comes along. There are these 10 to 12 phone calls, which one might presume would be a continuation of the harassment, but we now know are not any type of harassment. And then the December 10th incident. I don't believe a lot of times in coincidence. I don't believe that things happen all the time by accident. I agree. I think that was an intentional misdirection to the court in terms of what this should look like. That doesn't mean that I would end up any place different than where the magistrate was, but the magistrate was owed the benefit of having all of that information prior to making that decision. It is, in this court's mind, a glaring omission. So for those reasons, the court, in exercising its discretion, is going to grant the motion for an evidentiary hearing in this case.